DAMEYON POSEY. Paper. That's it.
Great, we'll go on the record in the state of Wisconsin versus DAMEYON POSEY, that's 26 CF 441. And we have a bail hearing in 26 CF 30 appearances.
John Bake for the state.
Mr. Posey appears in person in custody with attorney Clayton Kavanaugh. We received a copy of the new criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint appears to be correct, and Mr. Posey is eligible for public defender services.
Great, we'll make a finding of probable cause in the new case. In or not guilty pleas to the misdemeanors, state's position on bail in each of the cases.
Starting with the new case 26 CF 441, state is recommending $2,000 cash bail with the non-monetary conditions that the defendant be banned from the Musket Ridge Drive in Sun Prairie, that he have no contact with Bridget J, and that pretrial services be employed for GPS monitoring. As for the old case, 26 CF 30, state is requesting an additional $1,000 cash bail. Here, defendant has already posted $1,700 in his pending cases. He's violating very specific conditions, that being the address ban. He was most recently released, I believe, 5 days ago on February 19, and is violating his conditions. Therefore, cash is necessary and significant cash is necessary.
Great, the defense position.
I could just quickly confer with Mr. Posey.
Sure.
So let's, we can review another thing. It's okay. Okay, so let's start with the old case, the bond hearing rather than the initial appearance. With regard to that, my understanding based on my conversation with Mr. Posey is that he had a misunderstanding of when court was supposed to be, thought it was the 19th rather than the 16th. He showed up on the 19th and his attorney said something to the effect of that he'd file a bond motion, but it was never filed. Not an excuse for missing court on that day. It seems like it was just an error on his part, but he did try to address it, it appears, and it appears that no motion to quash was ever filed. Admittedly, it's a rather quick turnaround, so I understand that that can be the case for attorneys as well. So I would ask to simply reinstate bond in the old matter, kind of given that difficult situation. With regard to the new bond, I think, making sure I get to the right complaint here. Mr. Posey qualifies for public defender services. In this matter, I think that that fact indicates that the amount of bond requested is going to be pretty high for him to post. I don't think that would be necessarily possible. But I do think that there are some interesting suggestions from the state on non-monetary conditions that we think could protect the public rather than a cash bond, such as GPS monitoring or pretrial services. That would protect the public by keeping an eye on Mr. Posey's behavior and location, which could help protect the public and the victim here, without the need for significant cash bond. So if cash bond is deemed necessary, I would ask that it be set much lower than requested.
Great, any response?
No, Your Honor.
All right, well, there's a pretty strong case for cash bail. There was the failure to appear on February 16th. There was also a failure to appear on January 13th for a preliminary hearing in 26 CF 30. There was a motion to quash the bench warrant. It didn't provide any specifics, and obviously they got taken care of relatively quickly. But that undercuts the, hey, I made a one-time mistake with the court dates and screwed those up. He's out on bond in a bunch of cases. He's alleged to be violating specific conditions of bail. It's pretty strong with respect to the bail jumps. They found him in the place he wasn't supposed to be. He's actually been told he can't have contact with this particular victim in misdemeanor cases and violated that allegedly in 26 CF 30. He's posted $1,200 cash bail in 26 CF 30. I think the state's request is pretty well warranted at this particular point in time. There's a need for cash to assure appearance. There's a need for cash bail to protect the public. I am also going to order the pretrial services, and I'm going to do that in both cases. In 26 CF 30, I'll set $2,200 cash bail, and I will order pretrial services and GPS to monitor the ban from 244 South Musket Ridge Drive in Sun Prairie, that he not use or possess any dangerous weapon, and the no contact with Bridget J or any of her children will continue. In 26 CF 441, I'll set $2,000 cash bail. Pretrial services again, GPS to monitor the Musket Ridge address ban, the no contact again with Bridget J. I think they've given you the pretrial services. That's the yellow piece of paper. If you post, you got to be there by 10 a.m. on the business day following the posting of the bail. It's on the 5th floor of the courthouse, and if you're not there, then the bail can be forfeited. They'll issue a warrant for your arrest. So please comply with that.
Commissioner, I just have a question about the address on Musket Ridge. I think on the new case, the state has asked for a ban from the entirety of the road.
I actually think you're correct about that, and I think given the history, and I haven't heard any compelling reason he would need to be somewhere else on Musket Ridge. Let's just say a ban from Musket Ridge entirely in both cases. Appreciate that. As to time limits for the preliminary hearing,
We'll keep the comments.
okay, we are adjourned.
Next is ALVIN Ray.
Yeah.
Right.
Sorry, who was it?
ALVIN Ray.
Yep. Alvin, ready? Please stand the LS.
All right, we'll call the state of Wisconsin versus Alvin Ray. It's 25 CM 2048, and the county of Dane versus Alvin Ray, 26 FO 344. Appearances.
John Bake for the state.
Mr. Ray appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address on the complaint. The address on the complaint should be updated. 726 Vernon Avenue in Madison, 53713. Mr. Ray is eligible or is not eligible for public defender services.
All right, so they're going to give you the public defender info. If you're not able to hire an attorney after today, you could reapply with the public defender or apply for a county appointed attorney, which is the middle option. Probable cause has been found in 25 CM 2048. We'll enter not guilty pleas to the charges. We'll just enter a not guilty plea in the forfeiture, and that'll track along with the criminal case. State's position on bail.
State is recommending a signature bond with the condition that the defendant have no contact with any quick trips in Dane County.
All right, any objections?
Seems appropriate.
Okay, we'll order a signature bond, banned from all quick trip locations in Dane County, and we'll be adjourned.
Next is Ryan Spence appearing via Zoom.
Just gonna quick, Mr. Spence, can you hear us?
Yes, I can, yeah.
Sweet, thank you.
All right, we'll call the state of Wisconsin versus Ryan Spence. It's 26 CM 435 appearances.
John Bake for the state.
Mr. Spence appears by Zoom video from the Dane County Jail. Here in the courtroom for him, Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. You can waive its formal reading at this time. I don't have any update for the address or for the eligibility of Mr. Spence for public defender services.
All right, so Mr. Spence, we've got the beacon on the complaint for a mailing address. Is that still the best place to get mail?
Yes, sir.
Right, so thumbs up. And then they're gonna give you some info about the public defender. If you can't hire an attorney, contact.
I have an attorney
Okay.
through the public defender's office.
Oh, well, you may need to reapply because you have to apply in every single case. You're probably still gonna be eligible, but you gotta give them a call, so call so they can get you an attorney on this case after today. I'll make findings of probable cause and or not guilty pleas. There's a PSA report and it recommends cash bail. What's the state's position on bail?
State is recommending $500 cash bail with conditions that the defendant be banned from the 900 block of Badger Road, that he have no contact with Madison Police Officer James Doll, DOLL, except for legitimate law enforcement purposes, and that he not use or possess any dangerous weapons as that term is defined by statute. The defendant's fourth pending case, he has gotten signature bonds. It's my understanding that he's gotten signature bonds in all of his other cases, and he's constantly committing new crimes. Therefore, some cash is appropriate. He does also have some warrant history, too, from 2018.
Great. Attorney Sheehan?
Kavanaugh, but
Oh,
yes.
Kavanaugh, sorry.
No worries, we look kind of similar. So I guess I'll start with, in this case, it's not a violent crime. This is disorderly conduct, resisting misdemeanor bail jumpings, a couple of them. And so we're only able to post or to set cash bail here if it is deemed necessary to assure appearance in court. I have not, these are all misdemeanors, which are, and if there's several other open cases, they're not giving such exposure as to make someone flee. And I haven't heard anything about missed appearances. So I understand that we're frustrated with continuing to violate bond conditions. I think that makes sense. The remedy for that is bail jumping charges and not changes in bond by statute.
All right. Well, I think the state referenced a couple of failures to appear in 2018. There appears to be one in the last 2 years, according to the PSA. Based on that tool, it recommends cash bail has them almost to the top of the scale for failure to appear. One of the statutory considerations the court can take into account is whether this person's subject to bail conditions already. At the time of the arrest, he's out on a whole bunch of other cases. That gives me pause for concern about whether he's going to show up in court. And then we've got the resistive obstructive behavior. That said, they're misdemeanors. They're not violent crimes. I think the lesser amount of cash bail is sufficient to get him to appear in court. And quite frankly, the statute says all the bails in the other cases could be forfeited. In fact, it says shall forfeit those. So I'll set $250 cash bail here, order a ban from the 900 block of Badger Road. No contact direct with MAPD officer Dahl, except as necessary in the ordinary course of Officer Dahl's duties as a law enforcement officer, and that she not use or possess any dangerous weapons as that's defined by the statutes. And we'll be adjourned.
Thank you.
I'm saying, is that West Badger Road, East Badger Road? I think there's a direction around.
Just said Badger Road. Let me check here.
Break the complaints west.
Okay.
Do you include that or?
I think that'd be a safe bet.
All right. I assume there's no objection to that. So I'll add it and make it West Badger Road.
Next is QWASHI Morgan. Morgan, that's
That was more.
Right, we'll go on the record in the state of Wisconsin versus QWASHI Morgan Senior. It's 26 CF 439 appearances.
John Bake for the state.
Mr. Morgan appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address and the complaint does not need updating. He is eligible for public defender services.
Right, I'll make a finding of probable cause for the charges that apply to this defendant. I believe those are all felonies, so we'll address bail, state's position.
State is requesting a signature bond, and that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
Any objections?
No, seems appropriate.
Yep, seems appropriate. We'll order a signature bond. Condition will be that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And then Attorney Kavanaugh may talk to you about your right to a preliminary hearing in the next 20 days.
Thank you.
We're not sure. Next is MENKEM MEREDITH.
We'll waive time limits.
Okay, we are adjourned.
Right.
You're all good, my friend.
Yeah, that's right now.
Great, we'll call the state of Wisconsin versus MENKEM Young. It's 26 CF 437, and then we have a bail hearing in 26 CF 230. Appearances.
John Bake for the state.
Mr. Young appears in custody via Zoom video conferencing software. Attorney Andrea Savage from the Public Defender's Office appears in person. Mr. Young is eligible for public defender services. I imagine I have been appointed to other pending cases, so I likely will take the new one as well.
Okay, and waiving a reading of the new criminal complaint.
Yes, we would waive formal reading of the new criminal complaint, reserving all objections for a later court date. I can confirm the address on Nakusa Trail is current and up to date, aside from Mr. Young being in custody, and we would ask that the court enter not guilty to each misdemeanor count in the complaint.
Right, I'll make findings of probable cause, enter the not guilty pleas to the misdemeanors as requested, and then we'll address bail, state's position on bail.
State is requesting $500 cash bail on each case. On a new one, no contact with any Walmart stores, and that the defendant not possess or consume any alcohol. The defendant was on a bench warrant in both 20 CF 230 and 26 CM 272 when this happened. It's the state's position that he clearly doesn't care about his bail conditions. He doesn't care to come to court. Cash is necessary and appropriate in each case.
And Attorney Savage.
Thank you. I'll address kind of both collectively. I think there's some additional information that could be of interest to the court. But to start addressing the state's argument, we would ask that on the 2026 CF 230 case that a signature bond be continued, and we would respectfully request a signature bond in the new case as well. And some reasons for that, because I certainly understand the circumstances here. As indicated under the statute, that being 969, the ability to pay is a factor to be considered by the court. Mr. MENKEM is not able to pay $500 on any single case. He certainly is a long way, respectfully, from getting there on both cases. But getting more to the facts and the analysis for the court. A missed court appearance, I certainly understand that situation. With that being said, there was confusion. There was a mix-up on Mr. Young's part, and that is not any sort of disregard. That is, as the state mentioned, there is a misdemeanor case pending as well. Mr. Young believed his next court date was March 24th. That next court date in the misdemeanor case is in fact March 24th. As I said, it was just confusion. It was a mix-up, and the next set of circumstances goes a little bit more to that. There is quite a bit going on here. I think that it's clear from, frankly, all of the criminal complaints that mental health is at issue here. I think it is something to be addressed, and I think it really is at the forefront. Even with the new case, there is no indicia of intoxication in the history of cases. There really isn't that either. And so the bizarre fact of, allegedly having multiple bottles of alcohol, where that came from and that sort of conduct, I think is consistent with some mental health concerns that are raised in the prior complaints as well. And I think that's at the forefront here. And I think getting treatment in the community is how we protect the community. I think that's how we put Mr. Young in a position to be able to get to his court dates. And in the event that there is a failure, in the event that he's not able to comply with that, there are going to be remedies, and he will be looking at some time in a facility as well. So I do think that addresses that, but more than that, I do happen to know Mr. Young had an appointment, a medical appointment today that he obviously is going to have to reschedule. But it is something that he's working to address. He obviously did not get to that medical appointment. It is my understanding was to be in person for, a discussion. I don't think I need to get into it anymore, but just to say, I think at the center of a lot of the concerns here of the facts that we at least have at hand here, I think addressing those comes through addressing treatment and mental health concerns. And it is clear to me that there is a plan in place. In addition to that, I do happen to know Mr. Young is reaching out for employment opportunities as well. At this point, as I mentioned, he is not able to afford that $500 cash bail. That does not mean he's not doing anything about it. And so he is taking these steps within the community, staying local, and committing to addressing the needs that he has, the mental health aspect of things, the employment, the financial situation, that I do believe it's appropriate to give him the opportunity to do that. And I think he would receive better or more appropriate treatment and more comprehensive treatment if he's able to have that opportunity in the community.
And any response from the state?
Just briefly, I would also note there are failures to appear in 2 cases in March of 2024 for Mr. Young.
All right, and I may have misheard it. I think that there was a reference to a failure to appear in 26 CM 272 at the same time of 26 CF 230. It looks like in the CM case, he did not fail to appear. He posted $250 cash bail in relative short order, and that's the March 24th date that he has. So there's been another failure to appear in 2024. We're now on the 3rd case, all in very short amount of time. That's concerning. Then when he has contact with law enforcement and has a bench warrant from the other case, runs from law enforcement, all of that suggests some cash is warranted. I get the confusion that tends to happen when you keep piling up cases. $250 has apparently been enough to keep him showing up in that 26 CM 272 case. I'll set $250 cash bail in each of these cases. In the new case, I'll order a ban from all Walmarts and that he not possess or consume any alcohol. The prior non-monetary conditions in the other pending case will remain. Do you want a timely preliminary hearing?
Yes, we are not waiving time limits at this time.
Okay, since these are your cases, we'll make sure that the date that the clerk's got works for your calendar.
Right now, I'm looking at March 12th, 9:30.
I gotta push it to. Oh, that's cool, Jeff.
That will work for defense, if I may, Your Honor, just for the sake of the record. Just clarification. As the court had mentioned, there was that warrant that won the CF case. I believe I did not see a failure to appear on that CM case.
Well, I think I tried to correct that. I thought I heard the state say there was. I don't think there was.
Okay.
He had $250 cash bail and he's made all the court dates on that particular case. But then they had referenced in their rebuttal argument a failure to appear in 2024. So if I mixed that up, I understood it in my mind that there was the February 18th, the failure to appear, and then one in 2024, and only the one case, not the misdemeanor.
Yes, thank you. I appreciate you clarifying that.
Yep, we are adjourned.
Next is Maria Randall While Revoked.
Should be a detail.
Thanks.
We'll go on the record in the state of Wisconsin versus Maria RANGEL VILLAVAZO. That's case 26 CM 433. And then we have a bail hearing in 24 CM. Oop, my calendar moved. My calendar moved, so it scrolled all the way down to the bottom again. 24 CM 1565 appearances.
John Bake for the state.
Mr. Rangel appears in person with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in the new matter. We can waive its formal reading. We appear to have an updated address. 321 Tower Drive in Sun Prairie, Wisconsin, 53510. Mr. Rangel is eligible for public defender services.
Right, and we have certified Spanish interpreter Fred Svensson. I'll swear him in. Will you swear or affirm that you'll truly, accurately, completely, and impartially interpret the proceedings?
Yes, sir.
Okay. So as I said, we've got a bail hearing in 24 CM 1565. There's a failure to appear back on October 2nd of 2025. And then I'll find probable cause in the new case. Will enter not guilty pleas to the charges. State's position on bail.
State is requesting $500 cash bail in the old case, 24 CM 1565. And requesting $1,000 cash bail in the new case, with conditions that the defendant have no contact with Alexis P. or Jose R. Your Honor, defendant, as you mentioned, failed to appear in the old case in October of last year. She's out on bail in a case where Alexis P. is a victim. A condition of no acts or threats of violence was issued in that case. She has multiple failures to appear in the past. September of 2024, as well as that October date. It's clear that the defendant is a flight risk. There needs to be cash.
I should note, it looks like she ended up posting $250 cash bail in 24 CM 1565. And I see no indication it's been forfeited, so that's still applicable to bond. Attorney Kavanaugh?
If I just have one moment to confer, thank you.
Sure.
Yo ahorita no tengo ningún. O sea, yo lo que yo no tengo para pagar, yo lo único que puedo pagar es $60.
Okay, so I would point out, I think something that is relevant, that Mr. Rangel does not have any prior record as far as I can tell. I understand that there's one missed court appearance from October. And it appears that this is the only police contact she's had since. Reading the complaint, it's hard to get an idea of the situation that we're talking about. I think the circumstances are relevant to what we're talking about. To me, it appears that she was let back into the home and was staying there potentially. I understand that doesn't excuse the fact that that is a violation of her bond, but I think that changes whether she.
Well, I think she had a no acts or threats. I don't think she was prohibited from being there. The violation is because she allegedly engaged in threatening or violent behavior while in contact with that victim.
Thank you for that correction then. As far as I can tell from reading the complaint, this does not appear to be a situation where this is like premeditated violence or even really losing temper and wanting to cause harm, as much as Ms. Rangel's family appears to be concerned for her mental health. And that seems to be kind of what's going on here. I think that is a mitigating factor. In addition, Ms. Rangel is eligible for public defender services. She does not have an ability to pay additional bond, particularly not another 1,000. I don't think cash is necessary in this case. If it's deemed necessary, I ask to be significantly lower than what's been asked for.
All right, well, to her credit, she was on bond for quite a while before we had this. Unfortunately, then she allegedly violated a specific condition of bond in a violent manner. Then she was resistive, obstructive with law enforcement. We have 2 failures to appear, and one of those after having posted $250 cash bail. I see this as a concern of whether she's going to appear in court, not so much that cash is necessary to protect the public, although that is in play, given the nature of the charges. I'll set $400 cash bail in each case. She has the credit for $250 in the older case, and all the prior non-monetary conditions will remain. Well, actually, strike that. I think to be consistent, I'm gonna order the no contact direct or indirect with Alexis P in 24 CM 1565. The other no acts or threats to Leonardo and Jessica P will remain. But to Leonardo and Jessica P. And then the new case would be the straight no contact direct for indirect with Alexis P and Jose R. And we'll be adjourned.
Next is Tracy Kelly, if he's Griffin.
I had 2 bail bond hearings on mine, Salvador Rodriguez Pettis, is that not happening?
Sound familiar? What's the name again?
Zal EL with a Z, Rodriguez Paris. 24 CM 2299.
I don't
see that on mine.
I think you're probably good to go.
Just checking and see if don't get hold some problem.
Yeah.
So it's scheduled here.
I think you just have it on one calendar. It must have been taken off the some point.
Okay, great.
Hasta luego. I'm working my Duolingo just for him.
What's that?
I'm working my Duolingo just for him.
Next is SHAKUR Williams.
Oh, okay.
SHAKUR Williams. Good work. It's how you are. How you guys doing?
Hi, Mr. Williams.
Great, we'll go to the record in the state of Wisconsin versus SHAKUR Williams. It's 26 CM 441 appearances.
John Bake for the state.
Mr. Williams appears in person in custody with attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct. Mr. Williams is not eligible for public defender services.
I'm sorry, is there an apartment or unit numbers?
I don't believe. Is there a unit number to your address?
No. 1132.
Okay. And I think they gave you the public defender info. I see that on the back of the stack there.
I got fired. I was in it, so.
Okay, well, you'll need to reapply. We'll work on that.
Okay, so you may well be eligible, but you got to give them a call and reapply. If you're not eligible still, you could apply for a county attorney. That's the middle option. We'll make findings of probable cause and are not guilty pleas to the charges, state's position on bail.
State is recommending a signature bond with conditions that the defendant not operate a motor vehicle without a valid driver's license. that he not possess or consume any controlled substances or drug paraphernalia without a valid prescription.
Any objections?
No.
Right, I'll go along with it. These are nonviolent charges. It's a joint recommendation. I think there might have been an argument for cash bail given the number of cases and the alleged obstructing. So if you're picking up future cases or missing court, there's maybe a good chance that there's going to be cash bail in your future. So I'll order a signature bond. Conditional be that you not operate a motor vehicle without a valid driver's license, do not possess or consume controlled substances or drug paraphernalia without a valid prescription, and we'll be adjourned.
Thank you, I appreciate
Real
it.
good.
You're welcome.
Yeah, have a nice day.
You too.
I just feel sad. Next is Jeffrey Holman. Mr. Holman, Jeffrey Holman. His papers. Instead of the elements.
Right, we'll go on the record in the state of Wisconsin versus Jeffrey Holman. That's 26 CF 449, 26 CF 433, and 25 CF 1544 appearances.
John Bake for the state.
Mr. Homan appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the new complaint in this matter.
We should have two, and
Two new complaint.
one of them was a late ad because I hadn't seen that one.
Yeah, I have 433. What's the, that has 7 counts of,
49, it's 9 counts, fraud on innkeeper, party to the crime, resist, obstruct.
what a fun surprise.
Bunch of felony bail jumps and a misdemeanor bail jump for the last count.
Talk. Would I just be able to take a minute on that?
Yeah, I think they're printing you a copy of it.
I have it here, actually, sorry.
Oh,
about
you
that.
do have it. Okay.
It was just kind of hidden in my stack of
Yeah, no problem.
papers. Appreciate it, though. Okay. Okay, we reviewed that complaint as well. We can waive that formal reading as well. The address on both appears to be correct. And Mr. Homan is eligible for public defender services. He already has one. I assume it will go to that attorney.
Okay, I've had a chance to quickly review 26 CF 449. I'll make a finding of probable cause and find probable cause in 26 CF 433 as well. I'll enter not guilty pleas to the charges. Then we've got a pretrial violation report and a bail hearing in 25 CF 1544. I should note that Judge Highland reached out to the commissioners. He's in trial, and this is one that he had intended to just revoke bail and hold him until he could address it, but he's fine with us addressing it here today. But he thought high cash bail was likely appropriate, but obviously would hear any arguments. So he's blessed us to address 25 CF 1544 along with the new cases.
Before we launch in, if I could, I don't have a copy of the pretrial services report.
And I think it would be just simply the new arrest, but let me pull that up to see if there are other
Okay.
violations. But we can print you a copy.
Just want to make sure so I'm not blind here. This one I promise I actually don't have.
It definitely. Well, I was gonna say it definitely does cite the new arrest as the new violation, but it definitely does not. There was one on the 23rd and one on the 24th, which appear to be different. I will print both.
Sweet, thank you.
It does also have some passive information.
It's good to do thorough work.
Yeah, so it's a little weird. The one on the 23rd references the new arrest, and then
Thank you.
the one on the 24th references some missed tests.
Okay, 23rd or 20th?
The 23rd.
Oh, 24th. I see now.
All right, well, Attorney Baker will hear your position on bail in each of the cases.
Thank you. First, starting with the bail case, state is recommending a $4,000 cash bail increase for a total of $5,000 with the previous non-monetary conditions. As for 26 CF 433, state is requesting $5,000 cash bail with conditions that the defendant not operate a motor vehicle without a valid, not operate a motor vehicle at all, that he have no contact with Tasha S. TASHA, that he not possess or consume any alcohol, and that pretrial services be implemented to monitor the defendant's alcohol. Lastly, for 26 CF 449, state is requesting $1,000 cash bail with the condition that the defendant be banned from the Rockdale Bar and Grill. First, starting off, the defendant has just under a dozen cases. He has 3 pending OWI fourths, which means if he's convicted on all of them, that comes with mandatory prison, faces a lot of exposure. He's under numerous conditions of bail, not to operate a motor vehicle, not to possess any alcohol, or not to consume any alcohol, and yet he's doing exactly that in these cases. Cash was ordered in many of his open cases as well. Clearly, he's unable or unwilling to follow the court's orders. There are multiple pretrial violations for missing alcohol tests, for committing new crimes. There needs to be significant cash bail across these cases.
All right, I think the pretrial services violation report, actually the one on the 23rd, referenced an OWI fourth as one of the charges. Is that being declined by your office or still being reviewed, or what's going on with that?
It seems like the OWI 4 was not prosecuted, was declined.
Okay. But there are 3 other pending OWI fourths?
That's my understanding, yes.
Okay. All right, Attorney Kavanaugh, whenever you're ready, you can make your bail argument.
Yeah, thank you. I was going to point out the same thing that the court has already pointed out, that I don't see no OWI fourth charged here. So as for additional exposure, I think in the scheme of what we're talking about, the likely exposure hasn't really gone up all of that much. I guess I'll talk about the facts of the cases as well. With regard to the fraud on Innkeeper case, and obstructing, if I'm looking at the fraud on Innkeeper, I understand the amount of money at issue here doesn't change whether the elements are met. It was less than $100. It was like 80 some dollars. Look, I get that that's still going to be a fraud on Innkeeper, but when in the grand scheme of what fraud on Innkeeper can be, I think that's a relevant amount. It's very low. As for then the following bail jumpings, I mean, those are all following simply, that fraud on Innkeeper and the obstructing. The severity of the conduct, I think, is at play here, and that's, as severity goes, not too bad. The other one is just an obstructing, again, not a violent offense, with a bunch of bail jumpings following that obstructing. There's only one course of conduct there, and again, it's just that obstructing. Again, not good behavior, but in the scheme of behavior that we're talking about, it hasn't really been escalating. I think that's something to keep in mind. I haven't, maybe I was reading and I didn't hear it. I didn't hear anything about missed appearances in these cases. It's possible I missed that. But I believe that in all of these many cases he's been consistent about showing up, which I think goes in his favor rather than against it. I understand that we're concerned about violation reports. There's apparently missed breath tests here. I get that that's important. But again, I think that's different than a positive high. And the other violation appears to be related to an offense that wasn't charged. So I think that's also pretty relevant too. So it's only really one, and it's for a couple missed tests. I don't think cash is necessary at all in this case to increase all of this. I just don't think that it's relevant or if it's necessary given what we're looking at. I don't think there's a real risk of increased propensity to not show up to court. He's been showing up consistently up to this point, and this is not that much of an escalation. I think signature bonds are actually appropriate in this case. Again, I'm going to make the backup argument, as I always do, though, is if the court finds that cash is necessary, that's a whole lot of cash. And I just don't think that someone who's eligible for public defender services can realistically post it. Again, I think signature bonds appropriate, but if cash is necessary, I ask that it be less.
All right. I see it as cash bail cases. I grant that he's shown up in all these cases. He's also got over $7,500 cash bail between the 7 other pending cases. We've added 2 more to that here today. One of those was $3,000 that he's posted. So he's shown an ability to post substantial money. I guess that begs the question why there was a fraud on Innkeeper for $100, but that'll be a trial issue. He PBT to 0.02, so alcohol was on board, and I think he was driving a vehicle. It's super low. I understand why maybe they decided they weren't going to be able to prove that or charge that. That's still pretty concerning behavior for somebody who's got 4 OWIs. He's not supposed to be drinking and doing those things. He's on pretrial services. That doesn't really seem to be making things better. And maybe part of the problem is he's not taking the test, so they're not detecting the violations when they're happening. There's a need for significant cash bail. He's just shown himself to be a very poor bail risk. In 25 CF 1544, I'm just forfeiting the $1,000 cash bail. I'll set $4,000 cash bail with pretrial services and the prior conditions. In 26 CF 449, I think the $1,000 bail is appropriate. I'm going to order pretrial services there. We might as well equip him with a GPS and monitor the band from the Rockdale Bar and Grill as a condition. And in 26 CF 433, I think if he got charged with another OWI for $5,000 or something more than that would have been appropriate. I think a lesser amount is appropriate in that particular case because we don't have that. But again, we do have him violating pretty much all of his specific conditions of bail. I'm going to set it at $3,500 cash bail there. Order that he not operate a motor vehicle, that he not possess or consume alcohol, that he have no contact, direct or indirect, with Tasha S. And again, a condition of pretrial services to monitor the alcohol consumption there. You got to show up, as you're aware, to pretrial services no later than 10 a.m. in the business day following your release if you're able to post the bail. I believe the bail in 25 CF 1544 was not posted by Mr. Hohmann. Whenever people are posting bail, it's subject to forfeiture. They're at risk, even if you make your court dates, if you're violating conditions of bail or picking up new crimes. They do have the right to, have that reviewed, and the judge can take a look at that and see whether it's in the interest of justice or not. On the record before me today, I think it is appropriate and necessary to forfeit that. So you'd have to post the full $4,000 in that 25 CF case. Should we get prelims scheduled in a timely manner?
Yeah.
Okay, we will do that and we'll be adjourned.
Next is DAMARI Richardson, appearing via Zoom.
Yes. Here I am. Hello. Yeah, don't call it, just hold on.
Okay, we will call the state of Wisconsin versus DAMARI Richardson. It's 26 CM 430 appearances.
John Make for the state.
Mr. Richardson appears by Zoom video from the Dane County Jail. Hello. Here in the courtroom, Attorney Clayton Kavanaugh. We received a copy of a complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct, and Mr. Richardson is eligible for public defender services.
Mr. Richardson, you can hear us okay? Give us a thumbs
Yes,
up.
sir.
Okay.
I
We'll make
would-
a finding of probable cause for the charges in your case and are not guilty, please.
Yes.
The public safety assessment report, it recommends modest cash bail. What's the state's position on bail?
State is requesting $500 cash bail with condition that the defendant have no contact with any Kohl's stores. This is the defendant's third open case. It's my understanding that he has some failures to appear, I believe in 2023 and 2018.
Mr.
Yeah,
Richardson,
thank you.
if you can just hold on a second. I can't hear the prosecutor, and then you've got an experienced attorney who can make arguments on your behalf and certainly can talk to if he feels that it's necessary. Can you repeat that, Attorney Bake? I didn't hear the failures to appear.
Yes, of course. I believe there are 2 failures to appear in 2023 as well as 1 in 2018. Given the number of cases and given the failures to appear in the past, there needs to be some cash to ensure appearance and that the defendant follows his bail conditions.
And Attorney Kavanaugh.
Yeah, I think those are pretty dated missed appearances and not very many given that dated history. One's from 2018 that had to be cited in order to make that seem like a big number. Seems like if he's got 3 open cases now, I understand that they're actually pretty young, so I don't know if we can really determine one thing or another from them based on how new they are. There are some more recent cases. I don't see any missed appearances from those. Frankly, on a short review of the record, it's hard for me to tell if those are because he was in custody or not. I don't think we have a record here sufficient to determine that he is not going to show up for court. These aren't Act 3 eligible. These aren't significantly different than the ones he's already on, and we don't have any missed appearances for those. I think a signature bond is appropriate in this case.
All right. Well, the PSA tool recommends some cash bail. I guess my concern is the underlying cases are all very recent. They're so recent, he may have had no court dates since those were charged out, and then we pick up our third case in short order. I think the record is concerning enough that some cash is warranted. It's a retail theft. I'll set it as low as I think is reasonable to get Mr. Richardson into court. I'll set it at $200. I'll order a ban from all Kohl's locations and we'll be adjourned.
Thanks.
Next is Tracy Kelly. Where are we going? Go right. Ms. Kelly? Stand up and go.
Go on the record in the state of Wisconsin versus Tracy Kelly. It's 26 CM 429 appearances.
John Bake for the state.
Ms. Kelly appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint is correct. We have assessed Ms. Kelly's eligibility. We're pending verification on some things.
Okay, why don't we give her the public defender info and then she can check in to find out what's going on with that evaluation. If you're not eligible, you could apply for a county appointed attorney. That's the middle option, or hire an attorney on your own if you're able. I'll make a finding of probable cause, though. We'll enter not guilty pleas. And I believe we may have a victim who wanted to make a statement on bail or bond. I think they're on Zoom. We would just need them to unmute. Looks like they're maybe on a phone, so you'd have to hit *6 on the phone to unmute. So if we've got the victim for the Tracy Kelly case. All right, I think they're unmuted. Can you just identify yourself first?
Hi, I'm Allison Kelly,
Okay, and Ms.
and
Ms. Kelly, what did you want to let the court know about bail or bond?
I'm unsure of what that means. Can you please explain?
Sure. So today I have to decide whether to give a signature bond, which means that no cash bail needs to be posted for release. It's basically a person's written promise that they're gonna show up to their court dates and not pick up any new charges and abide by the bond conditions. And then I also need to address whether any specific bond conditions are appropriate. Some that might be in a case like this would be a no contact with you or your residence or something like that. And I don't know what the state's going to be asking for and what the defense positions will be, but those are the issues that are addressed today. Does that make sense?
Okay. Well, so what's the cash bail, I guess?
Okay, you would like cash bail ordered.
Yeah.
Okay. And do you have an opinion on whether there should be any no contacts or ban from your residence or other conditions?
No, the 72-hour no contact is fine, but from there, the contact is okay. Also, I was wondering, is there any other options for her? I don't think that she needs a criminal record right now. I think that she would be okay if she had like a psychological evaluation or took classes to move forward and learn from this. I don't think that a criminal record would help her at all regarding the incident.
Okay, I appreciate that, Ms. Kelly, and I just wanted to clarify because maybe there was a misunderstanding. You're not asking that the court order cash bail that she would have to post to get released as opposed to her just signing a piece of paper promising to show up to court, or do you think cash bail is necessary to get her to show up to her court dates or protect the public?
I don't fully understand the question. I'm sorry, but I'll just try to explain it to you. So whatever way we can get her out and she can still show up to the court dates is fine. So if that means posting cash bail, that's fine.
Okay, I appreciate that clarification and sorry to be confusing. I didn't get the impression you wanted her necessarily stuck in custody, given your position that you're okay with contact and would like the case dismissed. So I appreciate the input. Anything else that you wanted to say?
How much is the cash bail?
I haven't decided whether there'd be a cash bail or a signature bond yet. I haven't heard the arguments from the attorneys. I just wanted to get your thoughts on that if you had any positions.
Okay, thank you.
Yeah, you're welcome. What's the state's position on bail?
State is requesting a signature bond with the condition that the defendant have no contact with Allison K.
Right, any objections?
Objection to the no contact. I think we heard from Allison, this is, I will also note, I guess, since we're here, that there is no prior record in the past, like over a decade, as far as I can tell. I don't think a no contact is necessary based on what we see in the record and also from the victim's statement.
All right, and any response from the state?
Just briefly, I haven't been able to do a deep dive, but it's my understanding that the defendant has been involved in cases in the past, albeit it's been a while, specifically cases involving battery towards her children, and that's what we have here. Therefore, we think the no contact is appropriate.
All right, you're not disputing it's something that's 10 years or older?
Correct. It's further than a decade out.
Well, I think a signature bond's appropriate. I don't think Ms. Kelly needs to post cash bail to protect the public or to get her to appear in court, given the record is very dated. Given the victim's specific wishes, I'm going to order a no acts or threats of violence to Allison K. You know, if that doesn't work and you're back here with a violation of that, it's not uncommon for us to just simply order a no contact, even if the victim is saying they still want contact. So bear that in mind, and please abide by those conditions. to Allison, I don't have any authority to dismiss the charges here today. That's something I'm sure the DA's office is interested in, and a judge will be interested in those thoughts at any potential disposition in the case. I don't really have any basis to order a psychological evaluation or any of that sort of stuff. That would probably be more appropriate if there's ultimately a disposition in the case. And
Are there
so-
like classes she can attend? You know,
well, she can
to,
certainly
like,
attend any sort of treatment she wants on her own. I don't really have the authority to order it at this particular stage of the proceedings, and it might be something that is ordered if she's convicted later on.
okay.
I do want to note that the clerk noted the 72-hour no contact is still in effect until 8:50 a.m. tomorrow. I don't have any ability to change that here. That said, Allison, if you want that to be dropped before the full 72 hours expires, you can contact law enforcement to do that. Otherwise, until that's dropped, you need to have no contact, ma'am. If you have contact with Allison, you're going to be in violation of your bond conditions. It's going to be right back here. Okay? Any questions or clarifications about that?
Understood.
Okay. I wish everybody the best. We'll be adjourned. Thank you.
Thank you.
Next is Stevenson appearing via Zoom.
Might be easier to come down here.
Great. We'll go on the record in the state of Wisconsin versus Brian Stevenson, 26 CF 448. Appearances.
John Bake for the state.
Mr. Stevenson seems to appear by Zoom video from the Dane County Jail. So, Mr. Stevenson, if you hear us, can you give us a wave? Thank you, my friend. Here in the courtroom for him, Attorney Clayton Kavanaugh. We've received a copy of a criminal complaint in this matter. We can waive its formal reading. The address on the appears to be correct. Mr. Stevenson is not eligible for public defender services at this time.
All right, so Mr. Stevenson, the bail will give you the public defender info. If you can't hire an attorney on your own, you can give them a call and reapply. You can apply for a county appointed attorney. That's the middle option. And they could also point you in the right direction for that. I'll make findings of probable cause for the charges, enter not guilty pleas to the misdemeanors. State's position on bail.
State is requesting $5,000 cash bail with conditions that the defendant not operate a motor vehicle, that he not possess or consume any alcohol, and that pretrial services be employed to monitor the defendant's alcohol. Here it's alleged that the defendant is heavily intoxicated. It's also alleged that he drives the vehicle into the ditch and into a driveway, hitting an attended vehicle, causing injury to the occupants. The defendant continues down road, does not stop after striking that vehicle, shearing off power poles, live wires, and hits a tree. He's resistive on scene when law enforcement arrives. The defendant also has a pending flee elude and OWI second in Columbia County, which is Columbia County case 26 CF 76. He was placed on cash bond about a week ago in that case, of conditions not to operate a motor vehicle while under the influence of any intoxicant, is violating his conditions of bail, committing new crimes, continuing to drive while under the influence. Significant cash bail is necessary.
All right, and what was the amount again?
$5,000.
Right, and Attorney Kavanaugh.
I apologize. I might just need 1 minute to review. Okay, ready to go. So I guess I'll start with guess a motion to dismiss count one, operating while intoxicated causing injury. I'm trying to find references to actual injury in the criminal complaint here, and please correct me if I'm wrong, but I don't see any. The closest we get is a statement on page 5 where an officer reports that someone was transported to the hospital for evaluation of suspected injuries. We don't actually hear about any injuries. I don't hear that anyone stated that they were injured. I don't hear that any indication of what those injuries would be. I mean, even probable cause requires some underlying facts. And right now, all we have is maybe someone suspects maybe that there's injuries. I'll start there.
Okay, well, Attorney Bake, any response?
I could have a moment to review the criminal complaint. Your Honor, I apologize for the delay. I think Attorney Kavanaugh is correct when he says that the sort of only mention of the injury is the mention of the transport. However, at this time, I do think there is probable cause to prove the element that there was an injury involved in this case. Ultimately,
Oh, yeah, he's in court.
ultimately, they don't transport people if they're not injured. Also, given the allegations of the various damage, the various property damage and the observation of those damage on scene, I believe there's a reasonable inference to support the notion that there were injuries as a result of the defendant's actions as a result of his driving.
Great, and your response?
Yeah, just really quickly, as I'm just looking through the jury instruction on this too, it seems like injury is treated kind of similarly with pain. There's no statement that any kind of pain was caused.
All right. Well, it can be just pain, or it can be broken bones or all sorts of other injuries. I think for purposes of today, it barely meets the threshold, but I'll deny it. I think there's a reasonable inference given the severity of the crash and the fact they summoned EMS and had the person taken off to the hospital. If they said, yeah, I don't have any pain, I'm perfectly fine. I agree with Attorney Bake. That's an illogical conclusion that they would send somebody off to the hospital. Now, maybe they did. I think for purposes of today, there's at least an inference that somebody was complaining of some sort of pain to the body. So I'll deny that motion, but I think it was well-founded.
Thank you. With regard to bond, then I'll move on. As I'm looking at the Columbia County case referenced by the state, I see that $100 cash was what was required in that matter. I understand that in this matter, we're looking at something subsequent to that, which is a little more concerning. I understand that protection of the public is a question that we want to answer. We want to try to protect the public here. I don't think that a large amount of cash would be necessary, especially not something factors higher. I would ask for low cash for Mr. Stevenson in this matter.
All right. Well, counsel, correct me if I'm wrong. I don't think any of the charges are Act 3 eligible, but I should probably take another look at that. I think the OWI would have to be great bodily harm, but let me,
I believe you're correct.
I think you got my own thing out from under me. I believe you're correct.
but let me just take a look, because it matters, I think. Yeah, I don't see that the hit and run injury or the OWI causing injury second offense would qualify as an Act 3 eligible offense.
Hmm.
The OWI great bodily harm or OWI causing death certainly would. So I think a lesser amount of cash bail is sufficient to assure appearance in court. I do have concerns about that. You've got the fleeing, eluding. That's to me not consistent with somebody who's going to voluntarily appear. And then a pretty significant resisting, obstructing, where he's basically telling the cops to kill him or shoot him. They had to use tasers to deal with Mr. Stevenson. You've got the fact that he was violating specific conditions of bail, the exposures certainly going up, and I presume, you know, if he's convicted in the other county, you could be looking at an OWI third here as opposed to just an OWI second. I think there's a need for cash bail. He was already out on cash. I'm going to set it at $2,000. I'm going to order that he report to pretrial services. If he posts that to be monitored for alcohol use, I'm going to order that he not operate a motor vehicle at all. May not possess or consume any alcohol at all. As to time limits for the preliminary hearing,
We'll keep them.
okay, we are adjourned.
Next is Jennifer Opus. Opus. Takes down the elephants.
Go on the record in the state of Wisconsin versus Jennifer Kopis is 26 CM 439 appearances.
John Bake for the state.
Ms. Kopis appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of a criminal complaint in this matter. We can waive its formal reading at this time. The address on the complaint appears to be correct. And Ms. Kopis is eligible for public defender services.
Right, I'll make findings of probable cause, enter not guilty pleas to the charges, state position on bail. Oh, wait, there is a PSA and it recommends modest cash bail. Attorney Bake.
State is requesting $500 cash bail with the condition that the defendant have no contact with any Dick's Sporting Goods stores, that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription. Your Honor, the defendant now has 4 open cases. It's also my understanding that she has a fair amount of failures to appear in the past, notably one in 2024, 2020, and 2019 in Dane County. And I believe that's the extent of her failures to appear. Actually, it looks like she also has one in 2024 in Fond du Lac.
Okay, Attorney Kavanaugh.
I don't have that. I don't think I got a copy of the Kopis PSA. I apologize. How many does it show in the last?
None in the last 2 years. So that leads me to believe that the one in 2024 must have been in early February or sometime in January of that year. And then it says yes to the older than 2. It doesn't say how many.
Got it. Thank you. So looking at the case in CCAP, because I see what the state has pointed out as well, that there are other open cases. There are several pending ones, and there's some that are closed as well over the last 2 years. As far as I can tell, there have been a lot of court appearances, and she hasn't missed any in that time period in the last 2 years. She's had them. hasn't missed them. She's been out of custody for them. I think that's relevant when we're talking about whether she's likely to appear in court. That's the only consideration we have today because she hasn't done anything violent in order to be ACRI eligible. She's shown up for court as far as I can tell. These are not different in kind. They're certainly not escalating to felony level offenses. These appear to be relatively innocuous. And it seems like she has a pretty good history of showing up to court in the last 2 years. I would ask for a signature bond, despite the request for the modest cash bail in the PSA.
Right, and any response from the state?
No, Your Honor.
All right, so it looks like the other pending cases, and she quite frankly could have been charged with felonies here. She's posted $250 cash bail in each of those felony cases, so she obviously hasn't missed court, but that may have played a factor as well. What's concerning is we're now here on case number 4, and there has been a history of failing to appear. I think some cash is warranted at this point now that we're on case number 4. I'll set $300 cash bail, order a ban from all Dick's Sporting Goods, and that you not use or possess controlled substances or drug paraphernalia without a valid prescription. Had they charged you with all the bail jumps, certainly a higher amount would have been appropriate. We are adjourned.
Next is Hannah Lee.
Thanks to the PSA. Great.
Good work.
Can't see it, not in my mind.
Go excellent floor. So right there.
Okay.
Can't see much.
Call the state of Wisconsin versus Hannah Lee. It's 26 CF 445 appearances.
John Baker for the state.
Miss Lee appears in person in custody with attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint appears to be correct. Miss Lee is not eligible for public defender services.
Should I talk to them? We're gonna do some verifications,
Oh, got it.
because I'm disabled and my heart is very high, so I do not have much disposable.
Okay, follow up with us on
So
that.
they gave you their contact info, give them a call.
Yes.
All right. I'll make a finding of probable cause. There's a public safety assessment. It recommends a signature bond. State's position on bail.
State requests a signature bond with conditions that the defendant have no contact with a child victim listed in the criminal complaint, and that she not possess or consume any controlled substances or drug paraphernalia without a valid prescription.
Great. Any objections?
If I could just quickly confer, actually,
Sure.
no objection.
All right. And are we able to use initials? So it's something that actually can be enforced. I think the child victim's initials are in the publicly available probable cause affidavit. Actually, their full name and date of birth are there.
Yes, it's my understanding that the initials are N as in November, RS.
Order a signature bond. Condition will be that you have no contact, direct or indirect, with NRS, and that you not possess or consume any controlled substances or drug paraphernalia without a valid prescription. And then Attorney Kavanaugh is going to talk to you about right to a prelim in the next 20 days if he hasn't already done that.
We can waive them.
Okay, we are adjourned.
Next is Elvia Lopez. Elvia Lopez. Good work. So the Delaware.
Great. We'll go on the record in the state of Wisconsin versus Elvia Lopez. It's 26 CM 440 appearances.
John Baker for the state.
Ms. Lopez appears in person in custody with attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. I don't I do have an updated address, 8119 Aberg Avenue, Madison 53704.
Is that the job center?
We just want to make sure it's not 1819 Aberg, the job center.
Oh, it is a job center?
Yeah.
Got it. Well, there you go. Typo on our part. Good catch.
So if you wanna update your address on your paperwork to match, it's 1819.
Got it. Thank you. Ms. Lopez is eligible for public defender services.
Great, I'll make findings of probable cause and are not guilty. Please, state's position on bail.
State is requesting $500 cash bail with the conditions that the defendant have no contact with Raphael A-G except through third party for childcare. Raphael spelled R-A-P-H-A-E-L. And that the defendant not consume or possess any alcohol. Here, it's alleged that the defendant has similar or a history of similar behavior in the past with the same victim. The defendant's PBT was a 0.22 at the jail, so she was quite intoxicated. She also has a history of miscourt, although some of those are dated. The most recent was in April of 2025. She has an escape and flee elude charge in the past. She's been able to post cash in the past. State believes some cash bail is necessary to ensure appearance in the future.
All right, and the prior history involving this victim, is that something that resulted in criminal charges and convictions?
I don't believe so, but I'll double check as the defense attorney is speaking.
I'll actually confirm briefly first.
Sure, go ahead.
It does seem that there were charges, but to my understanding, no convictions.
Well, it looks like in 25 CM 11, there was a conviction for disorderly conduct as a domestic. The only listed victim was the same one in this case. But the battery got dismissed out of that. I guess the clerk is also noting, it looks like 25 CF 1829.
I apologize, you're correct.
CF 618. Okay, go ahead, Attorney.
Sorry, can I get a quick TLDR on what was just being said? Sorry, I was doing.
So I had asked whether there were any convictions, and the Attorney Bake said he didn't think there were. It looks like there was a disorderly conduct conviction involving the same victim, and then convictions in a couple of felony cases.
I didn't confirm the conviction, there were at least charges.
Let me confirm that. '25 CF 618 resulted also in a disorderly conduct conviction. Looks like again, the only victim in that case, and I'm going by the bail conditions, was also Raphael. So I see two DCs, unless I'm missing something.
Okay.
Go ahead.
Thank you. I think that's relevant because I wanted to make sure that when we're looking at the record, we can see what was dismissed and we can see what was convicted. We have two disorderly conduct convictions, Class B misdemeanors in the past. Right now, we have misdemeanor cases here. They are actually eligible, but I think what we need to try before we try cash bond here is no contact. We have no indication that she would fail to respect the court's order in this case. I think non-monetary conditions would be sufficient to protect the public and the victim in this case. I don't see a history of failing to follow those court orders. In this case, Ms. Lopez is again, public defender eligible, does not seem, according to my conversation with her, to have much in the way of cash in order to post. And I just don't think it would be necessary here to protect the public. I ask that we try those non-monetary conditions first and give her a signature bond.
Any response from the state?
No, Your Honor, the state would rest on its previous argument.
All right, well, she has shown the ability to post cash bail in the past, according to the state. There was the failure to appear in April of 2025, I believe. There's also the flee and elude behavior, escape convictions. None of that's great from an appearance perspective. It's an Act 3 eligible offense. It is concerning that there's been multiple other cases. Less concerning than if she got convicted of actual batteries. I guess where I come down on it is some cash is appropriate. I'll set it at $300. Order a no contact direct or indirect with Raphael AG. Except when using a third party for purposes of child placement exchanges, that you not possess or consume any alcohol. I think the no contact is absolutely necessary and appropriate given the history. We are adjourned.
Next is Christina Tully. Steve, that's right.
Did I respond?
Oh,
this one. Oh, Billy.
Go on the record in the state of Wisconsin versus Christina Tully. It's 26 CM 432 appearances.
John Baker for the state.
Ms. Tully appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct. Ms. Tully is eligible for public defender services.
Okay, I'll make findings of probable cause for the charges that apply to this defendant and are not guilty, please. State's position on bail.
State recommends a signature bond with the condition that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription.
Any objections?
Seems appropriate.
Okay, we'll order a signature bond. Conditional be that you don't use or possess controlled substances or any drug paraphernalia without a valid prescription, and we are adjourned.
Thank you for Jocelyn Yancey. Stand on the audience.
We'll go on the record in the state of Wisconsin versus Jocelyn Yancey, 26 CF 436 appearances.
John Baker for the state.
And Ms. Yancey appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. I have an updated address, I believe. 952 Rise Lane, RISE Lane, Madison 53714. Ms. Yancey is eligible for public defender services.
All right, I'll make findings of probable cause and are not guilty plea to the misdemeanor charge. And there's a public safety assessment. It recommends modest cash bail. State's position on bail.
State recommends a signature bond with conditions that the defendant have no contact with Jill S, JILL. That should be banned from the 10 block of South Blair Street. And that she not possess or consume any alcohol.
All right, any issues with those?
We agree with those terms.
Okay, we'll order a signature bond. Conditions will be a no contact direct or indirect with Jill S. Banned from the 10 block of South Blair Street and that she not possess or consume any alcohol. And then Attorney Kavanaugh will talk to you about your right to a preliminary hearing in the next 20 days.
We can waive the time limits.
Okay, we are adjourned. You're welcome.
Next is Robert Shipman, appearing via Zoom for a forfeiture. I was advised by the bailiff, it's very noisy down there, so it might be on.
Okay.
The bailiff just advised me that Shipman indicated to the bailiff he was not gonna participate.
Okay, well, then we'll just enter a not guilty plea on his behalf, take that as him standing mute. And he's got 10 days to make a request for a jury trial and post $36 in non-refundable jury fees. And we are adjourned.
Next is Ruth Holton. He sounds.
Right, we'll go on the record in the state of Wisconsin versus Ruth Houghton. It's 26 CM 424 appearances.
John Bake for the state.
Ms. Houghton appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address of the complaint is correct. She is eligible for public defender services.
Right, I'll make a finding of probable cause and are not guilty pleas to each of the charges. State's position on bail.
State recommends a signature bond with conditions that the defendant have no contact with child 1 and 2 as listed in the complaint. And I can get initials for you, Commissioner, afterwards. Also that the defendant not possess or consume any alcohol.
Right, looks like the initials might be JTT and HEH according to the PC affidavit.
Yes, I believe that's correct.
All right, any objections?
No objection to the bond. I have a motion to make.
Sure.
I will move to dismiss counts 1 and 2, the neglecting a child charges in this case. What I'm looking at when I read the criminal complaint is that Miss Ruth was intoxicated, that she had passed out from alcohol, was asleep at times. I also see in the criminal complaint that the children were, quote, fine, in good spirits and healthy, end quote. A parent being temporarily drunk and asleep, even under bad circumstances, is not enough for a neglecting a child charge. The elements require that Miss Houghton failed to provide necessary care, education, or protection from drug distribution or manufacture. I don't see any failure to provide necessary care here. We have a short period of time, apparently, a matter of just over an hour, that I can see in the criminal complaint, certainly within a single evening. I don't see any indication that she failed to provide necessary care, or that she, then additional element, that she seriously endangered the physical, mental, or emotional health of the child, which means to create a serious risk of harm or injury. I don't see anything to indicate that at all. All that I see here is that she was drunk. That does not inherently lead to neglecting a child charge.
Right, and any response from the state?
Yes, Your Honor. Here, as alleged, the defendant was intoxicated. There were text messages to family members saying that, well, suicidal statements essentially by overdosing with pills. Family comes home to check on the children, and no one else is there except for the defendant, essentially passed out, presumably on pills or intoxication or both. Given that information, there is probable cause that it meets the elements of child neglect, and we would ask that you deny the motion to dismiss.
All right, and any response?
Yeah, just quickly. I mean, if she had been entirely absent from the home for the period of time alleged, entirely gone, I would think that would be crazy to file the charge for neglecting a child. So her being there drunk, I mean, that's not uncommon. As a parent being drunk and not having someone for a couple of hours to watch their kids is not neglecting a child. We may not like it, maybe it's even disorderly, but there is no indication that she failed to provide necessary care, and there is no indication that she seriously endangered their physical, mental, or emotional health. We don't have neglecting a child.
All right. Well, I think it's significant that we're looking at a 2-year-old and a 6-year-old. You know, if we had teenagers, then they could maybe fend for themselves much easier than a 2-year-old or a 6-year-old. And she wasn't just intoxicated, she was passed out cold. In other words, she was not responsive to children that may have been crying or whatever. I imagine one of them likely was because the complaint says they had a soiled diaper. To me, that's not providing the necessary care. And she wasn't in the condition to do that, but for somebody coming over there and taking control of the situation. So, well, I see the argument and the point, and I think it's ultimately going to be a jury trial issue. I'm going to deny the motion to dismiss. And then was there an objection to the signature bond
No.
conditions? All right, so order a signature bond. Conditions will be no contact, direct or indirect, with JTT and HEH, and that you not possess or consume any alcohol, and will be adjourned.
Next is Summer Potak. Right, sure, right.
Who's next? Sorry.
Potak, P-O-T-E-C-K. Call the state of Wisconsin versus Summer Potak. It's 26 CF 442 appearances.
John Bake for the state.
Ms. Potak appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint is correct, and Ms. Potak is eligible for public defender services.
I'll make findings of probable cause and or not guilty plea to count 2. State's position on bail.
State recommends a signature bond with the condition that the defendant not consume or possess any controlled substances or drug paraphernalia without a valid prescription.
Right, any objections?
Seems right.
Okay, we'll order a signature bond. Condition will be that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. And then Attorney Kavanaugh will talk about your right to preliminary hearing.
Okay, so. No, we can waive the time limits.
Okay, we are adjourned.
Next is Paola Gutierrez, appearing via Zoom for a bail bond.
Yeah.
Right, we'll go on the record in the state of Wisconsin versus Paola Gutierrez in 26 CM 106 for a bail bond hearing. There's also the County of Dane versus Paola Gutierrez, 26 FO 337 appearances.
John Bake for the state and county.
Ms. Gutierrez appears by Zoom video from the Dane County Jail here in the courtroom for her attorney Clayton Kavanaugh. Ms. Gutierrez, can you hear us? Wave if you can. Perfect, thank you. Just want to make sure you know what's going on. We have received a copy of the criminal complaint in this matter. We can waive.
And I think.
Oh, wait, this is a bond hearing.
Appearance, it's just a bond hearing, and so we are here because Ms. Gutierrez did not appear on February 20th of this year. I guess I'd be interested to know how she ended up in custody. If she wants to provide that information, I'm happy to hear that. And it's always good to make sure we still have a good address. We were using the Aberg Job Center previously. And at the time, I don't know if we knew anything about whether she was eligible for a public defender. So if you have any of that info, that'll also be useful.
Let me check.
Oh my gosh, how many go to the summer? No, it would be our days off for our days off. I feel like I'm gonna get.
Um,
All right, next piece.
So the notifications do.
I don't see if she's applied.
Okay, so Ms. Gutierrez will get you the public defender info. If you can't hire an attorney, give them a call to see if you're eligible. And give us a thumbs up, if you can hear us okay.
I think I left.
All right, I see a thumbs up. And I'm not sure that we're gonna be able to hear her. I think all the noise is coming from somebody else. Maybe we'll hear with the state's position on bail first, and then we'll give you an opportunity to speak with her if you need to.
State doesn't object to signature bond with the prior monetary conditions.
All right, I assume there's no objection to that. We'll reinstate the signature bond. Looked to me like she may have turned herself in. That's a significant factor, and it was a very short amount of time she was on the warrant. So we'll reinstate the signature bond with the prior conditions. We'll just enter a not guilty plea on the forfeiture case, and that'll track along with the criminal case. So I think you're getting released today. Can you give me a thumbs up though if the Aberg Job Center is still the best place to get mail? Or a thumbs down if it's not? Is the Aberg Job Center the best place for mail? And they're muted. Maybe we can unmute if he's trying to provide a better address.
It's the Beacon.
Okay, thank you. We'll update it to the Beacon, and if you got a cell phone, you could sign up for text message reminders just to make sure you don't miss future court dates. We are adjourned.
Next is Jeremiah Moore. Jeremiah Moore.
Oh, are there two?
More.
Okay, we'll go on the record in the state of Wisconsin versus Jeremiah Moore. It's 26 CF 446 appearances.
John Baker for the state.
Appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct. And Mr. Moore appears to be seeking private counsel.
Okay, and that's certainly fine. If you can't, after today, you could always apply with the public defender's office. If you get caught in the middle, you could apply for a county appointed attorney. I'll make findings of probable cause, and the deputy's giving you the public defender info. Enter not guilty plea to the misdemeanor. State's position on bail.
State recommends a signature bond with conditions that the defendant not use or possess any dangerous weapons, as that term is defined by statute, and that he not possess or consume any controlled substances or drug paraphernalia without a valid prescription.
I think most of that, I don't think we have a problem with. I think one thing that I do want to follow up on is the no carrying dangerous weapons as defined by statute. I understand that we have carrying a concealed weapon as an offense here. I don't see any indication that anything beyond the manner in which he was carrying it was illegal. There's no dangerous conduct as far as I can tell. I don't think it's necessary to order that he just can't have any dangerous weapons at all. I think that the current law saying you can't carry a concealed weapon will probably be enough in this case moving forward. The rest of the bond conditions, no problem with though.
Right. Well, I'll order a signature bond. I'll order that you not use or possess controlled substances or drug paraphernalia without a valid prescription. I am gonna order the do not use or possess any dangerous weapons, as that's defined by statutes to include firearms. Essentially, what would be alleged here is that he was an armed drug dealer at the time. There's certainly a public interest in avoiding that. We've certainly seen a lot of violence in our community over the years. When drugs are involved and guns are involved, I'd like to see Mr. Moore safe and everybody else safe. I think it's an appropriate condition because he also wasn't possessing that firearm in a manner that he was legally allowed to, at least according to the complaint. So, what about time limits for a preliminary hearing?
Let me.
See multiple bookings when somebody hadn't been released. So that's the last one. Oh.
We can waive the time limits.
Okay, we are adjourned.
Next is Michael Cedars. This. Oh, geez.
We'll call the record in the state of Wisconsin versus Mike Cedar. It's 26 CM 434 appearances.
John Baker for the state.
Mr. Cedar appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint is correct. I don't have any, he is seeking private counsel.
Okay, that's certainly fine. If you're unable to retain private counsel, you can apply with the public defender again. The deputy's giving you that information. And if you're caught in the middle, you could apply for a county attorney. That's kind of the middle option. I will find probable cause, enter a not guilty plea. And the public safety assessment recommends a signature bond, state's position on bail.
State requests a signature bond with conditions that the defendant be banned from the SHAKUR Parktown Lanes, spelled Schregler, SCHWOEGLER. That he not possess or consume any controlled substances or drug paraphernalia without a valid prescription.
Right, any objections?
Seems fine.
All right, we'll order the signature bond, a ban from Schwegler Parktown Lanes that you not use or possess controlled substances or any drug paraphernalia without a valid prescription, and we'll be adjourned.
Thank you.
Next is Jermaine Peoples.
Go on the record in the state of Wisconsin versus Jermaine Peoples. It's 26 CF 440 appearances.
John Baker for the state.
Mr. Peoples appears in person in custody with Attorney Clayton Kavanaugh. The address in the complaint appears to be correct. We received a copy of the complaint. We can waive its reading. The address in the complaint is correct, and Mr. Peoples is eligible for public defender services.
Great, I'll make a finding of probable cause for both charges. And there's a PSA report, recommends modest cash bail. State's position on bail.
State is requesting $1,000 cash bail with conditions that the defendant have no contact with Romale G, ROMALE, and that he not use or consume any controlled substances or drug paraphernalia without any prescription, without a valid prescription. The defendant here is on bail. He's a convicted felon on bail for felon in possession, as well as possession with intent to distribute THC, as he is charged here. He posted $300 bail less than a week before this arrest. He's got open cases. He's violating conditions of bail, committing the same crimes. State believes that some cash is necessary.
And Attorney Kavanaugh.
Yeah, upon my review of CCAP and of the PSA, I think I see something that is relevant to our discussion here. That there is apparently one failure to appear ever. It wasn't in the last 2 years. Prior to that, there are none. I think that's relevant. We're talking about the question of whether, only talking about the question of whether cash bond is necessary to assure Mr. Peoples' appearance in court in the future. I mean, with only one missed appearance with what we've heard are pretty serious cases in the past. I think that this is not different in kind than what we saw before. It's a case, being honest, in Dane County, it's not a kind of charge that will very likely end in prison or anything really, really high. And if we're talking about protection of the public, although technically we're not, I still think it's relevant, kind of adjacently. THC is not one of the drugs that we are, it's illegal. It's not one of the drugs that we are most concerned about. It's no cocaine, it's no methamphetamine. So, you know, I get why the state is concerned. I don't think we need cash here to assure his appearance in court. Practically speaking, exposure is not all that high. I think despite the modest cash bail requested in the PSA or suggested by the PSA, I don't think we need it. I think pretrial supervision might not be a terrible idea in lieu of that, though.
Well, I guess I'm not exactly sure what pretrial services would do. I guess maybe testing for drug use, but he's charged with, you know, being a drug dealer, basically, the possession with intent to deliver. So I'm not sure that that's a good use of pretrial services. We, in many times in the last few years have run out of capacity for referrals. I don't want to end up there when we got somebody that maybe really needs it. You know, the PSA suggests some cash bail. There's been one failure to appear, but it has been recent. And he's already out on cash bail. That's kind of a bad look. He had some cash on the line and then is allegedly doing similar stuff, although he didn't have a firearm this time, which is a good thing. I don't think $1,000 is necessary. I'll set it at $500. I'll order a no contact director and direct with Ramal AG, and that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. What about time limits for the preliminary hearing?
We'll keep them.
Okay, we are adjourned.
Sorry, sir. This Dale Bosley.
We'll go on the record in the state of Wisconsin versus Dale Bosley Senior. It's 26 CM 431 appearances.
John Bake for the state.
Mr. Bosley appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct, and Mr. Bosley is eligible for public defender services.
Great, I'll make a finding of probable cause and or not guilty plea to the charge. State's position on bail.
State recommends a signature bond with the condition that the defendant not use or consume or possess any controlled substances or drug paraphernalia without a valid prescription.
Great, any issue with that?
Seems appropriate.
Okay, that's reasonable. We'll order a signature bond. Conditions will be that you not use or possess controlled substances or any drug paraphernalia without a valid prescription, and we are adjourned.
Thank you.
Good luck.
Next is Connor Braverman.
Braverman.
We'll go on the record in the state of Wisconsin versus Connor Braverman. It's 26 CF 434 appearances.
John Bake for the state.
Mr. Braverman appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the complaint in this matter. We can waive its formal reading at this time. Mr. Braverman, or the address in the complaint appears to be correct. Mr. Braverman is eligible for public defender service.
Great, I'll make a finding of probable cause. State's position on bail.
State requests a signature bond with the condition that the defendant be banned from all Target stores.
Any objections?
No.
Seems fine.
Okay, we'll order a signature bond. Condition will be a ban from all Target stores. What about time limits?
We'll waive time limits.
Okay, we are adjourned.
Wait, sorry, sir. Next is Victor Giannis.
Giannis.
Go on the record in the state of Wisconsin versus Victor Yanez Jr. It's 26 CM 357 appearances.
John Bake for the state.
Mr. Yanez appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint is correct, and Mr. Yanez is eligible for public defender services.
Great, I'll make findings of probable cause. I think there's a DOC hold that's still in place. State's position on bail.
State is recommending a signature bond. We would also ask for, just one moment. We would ask for the condition that the defendant have no contact with Rose Marilyn I. That's spelled ROSEMARILYN. There's no space in between Rose Marilyn.
Okay, any objections?
Seems fine.
Great, we'll order a signature bond. Condition will be a no contact direct or indirect with Rose Marilyn I, and we'll be adjourned.
Thank you. Good luck, man.
Next is Willie Benson for forfeiture.
Great, we'll go on the record in the County of Dane versus Willie Benton. It's 26 FO 343 appearances.
John Bake for the county.
All right, and so Mr. Benton, the good news is you're not getting charged with a crime out of the arrest. It looks like there might be a DOC hold that's still in place. That's gonna be a separate issue you're gonna have to talk to your agent about. But this is the type of charge that can be resolved today because it's non-criminal. They'll have an offer. If you want to accept it, you can be done with it. If you don't, it's still not gonna affect your custody. And if your agent drops the hold, this wouldn't be holding you, okay? Is there an offer?
There doesn't seem to be an offer in here, which is unusual. I would just ask for court costs.
Okay, so if you wanted to enter a no contest or guilty plea to the county disorderly conduct charge, which is non-criminal, you'd have to pay court costs of $114.50. It's not like bail, you don't have to post it up front. You gotta pay it in the next 60 days or work out a payment plan. Did you want to accept that offer? Or do you want to contest the charges?
Just get it over with.
Okay, I'll accept your no contest plea to the charge, or you pay the court costs. They're gonna give you some info about making the payments, and we'll be adjourned.
Next is Tristan Moore for a bail hearing.
Great, we'll go on the record in the bail hearing for Tristan Moore. It's 26 GF 37013. Appearances.
John Bake for the state, and I'm sorry, could I get that GF number again?
26 GF 37013.
Thank you.
26 GF. I might ask for that one more time. I'm so sorry. It's a strange thing. 26 GF
37013.
If you're looking on the public TCAT,
Oh.
likely won't hear the Wisconsin Supreme Court decided with public hearing that type of case and.
Can I get
It
the
just means
name
we don't have a
again?
criminal complaint, and under Rule 206, he was entitled to a bail hearing if he didn't have charges filed. But we can get you copies of the PC affidavits if you don't have those.
That'd be great. Thank
We'd be
you.
addressing bail today.
Could I just get that name again? I'm just not seeing it up here.
Tristan Moore, and maybe I'm pronouncing his first name wrong.
Right.
Okay, TRISTIAN,
Oh, God.
common spelling of Moore.
Then you do it, it's never heard that else.
I think I got it here now.
1823.
Yeah, thank you. Thanks.
Well, I'm not sure we got all the appearances while we were sorting out the case numbers and stuff. Maybe we can get those again.
John Bake for the state.
Mr. Moore appears in person in custody with Attorney Clayton Kavanaugh.
All right, and do we have a good address for Mr. Moore?
We currently have 815 Cedar Street, apartment 405. Correct.
Okay, and do you know if he's gonna be getting a lawyer through the public defender?
He is eligible.
Okay, so he was taken into custody, it looks like on February 20th. Probable cause has been found for second-degree sexual assault, false imprisonment, disorderly conduct, misdemeanor bail jumping, and one probable cause affidavit, and then a resisting PC affidavit. Probable cause was found by Judge Kondar. So I guess I'll turn to you, Attorney Bake, in regards to why we don't have complaints and if we're expecting one, when that might be.
So I have a note in here that we need at least 45 days until the next initial appearance for law enforcement to conduct additional investigation. We would be asking for a signature bond with some non-monetary conditions. I can list those out now.
Sure.
That's no contact with the child victim, ZER, as well as a ban from the 800 block of Cedar Street in Madison. So if we could set the IA out a month and a half or so, I think that would be ideal.
All right, and any objections, Attorney Kavanaugh?
No, signature bond feels appropriate until they file that
All right.
complaint.
So is there someplace else that you could reside at, Mr. Moore? If I abide by the ban from the Cedar Street address, I believe you're gonna have to live someplace else. Is there some other place you could live or get mail? Do you know the address? And if you don't,
I'll have to get it.
okay, just make sure that you update the court and you can let the public defender's office know about that. All right, so I'll order a signature bond. I'll order a no contact direct with the child victim with the initials ZER and a ban from the 800 block of Cedar Street. And do we know what that date and time is gonna be for the initial appearance?
The date I pull out of my calendar at is April 13th at 8:30.
Okay, does that work for you, Mr. Moore? Okay, you're gonna get some paperwork with that on that. They won't send out another notice, so make sure you hold on to that. There's some serious charges here. I don't know whether you're gonna get charged or not, but you certainly don't want to miss that court date. And you're out on bail, you don't want to be picking up bail jumps, so make sure you abide by all those conditions, okay?
Thank you.
All right, we are adjourned.
Next is Tony Stewart.
Great, we'll go on the record in the state of Wisconsin versus Tony Stewart II, 26 CF 447 appearances.
John Bake for the state.
Mr. Stewart appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the complaint. I'm just going to take a minute to read it before I waive its reading.
Sure.
Hey Ray, when was that IA date for the previous?
I want to say it was April 13th.
Okay.
April 13th, 8:30.
Thank you.
There we go. Somebody was negative.
Okay, ready to go. We can waive its formal reading further than now. The address on the complaint appears to be correct. Mr. Stewart is not eligible for public defender services.
Okay, so, Mr. Stewart, they've given you the public defender info. These are real serious charges. You're gonna want a lawyer. If you can't hire one, you could apply for a county appointed attorney. That's the middle option, or you could always reapply with public defender if your circumstances change or you think they did the calculations wrong. I'll make a finding of probable cause for the charge. There is a public safety assessment report, recommends cash bail. What's the state's position on bail?
State is requesting $50,000 cash bail with conditions that the defendant have no contact with Ariana L, ARIANNA, and that he not possess or use any dangerous weapons, as that term is defined by statute. Obviously, here we have an Act 3 eligible offense. In short, it's alleged that the defendant tried to kill the victim, specifically by stabbing her. This is a strong case. There are multiple witnesses. Defendant has a violent history, has multiple felony convictions. I believe I saw ones for substantial battery and burglary. There's a lot of exposure with a charge like this. Significant cash bail is entirely justified. I did see one failure to appear in 2020. That was the most recent one.
Okay, and Attorney Kavanaugh?
We're not going to bother talking about the failures to appear. I think we know what we're talking about here. That amount of cash is astronomical. I understand that this is a Class B felony and it has a very serious allegation here. That amount of cash is just going to be far and away above the ability of Mr. Stewart to pay. It becomes meaningless after a certain number. I think that's far beyond the meaningless number. I would ask for a reduced amount of cash. The non-monetary conditions do make sense, though.
All right, and the amount that was requested was $50,000?
Yes.
Well, he's looking at Act 3 eligible offense, and the way I understand Act 3 or read that is it can protect the public in a couple of manners. One, it can be an amount that somebody is able to post but wouldn't want to forfeit, so they're not gonna violate bond conditions or commit any other crimes against the public. The other way is it ends up being kind of preventative detention that somebody can't post it. The amount that's been requested, quite frankly, is less than what I've set in a slew of attempted homicide charges over the last almost 15 years. And he's somebody who's got 3 or more prior violent convictions, according to the public safety assessment. If convicted, it's not a stretch to think that there would be a significant amount of time in prison that provides a lot of incentive not to show up in court. I don't think a lesser amount would be sufficient to do that. It's a super strong case. He's essentially witnessed by some individuals, allegedly confesses to the actions, and not only that, confesses to the intent to kill. So there's just a lot of risk if Mr. Stewart is out without significant cash bail, that he's not going to show up, or the public would be at risk. I'll set $50,000 cash bail or no contact, direct or indirect, with Ariana L, and that you not use or possess dangerous weapons. And since a knife isn't always a dangerous weapon, and given what's alleged here, I'm going to add to that an order of condition that you not use or possess any knives either, even if they wouldn't ordinarily qualify as a dangerous weapon. What about time limits? Should we just get a prelim set?
I think we should.
Okay, seems reasonable. We are adjourned.
Next is Gregory Cooper for a forfeiture.
Sorry, what was it?
Gregory Cooper.
Thank you.
The forfeiture.
Oh, never mind.
Oh, no.
Thanks. We will go on the record in the County of Dane versus Gregory Cooper. It's 26 FO 335 appearances.
John Bake for the county.
Great, and Mr. Cooper, the good news is I think you're going to get released today no matter what. They didn't charge you with a crime. What you've been charged with, county disorderly conduct, is a non-criminal charge, so you're going to get released today no matter what. That said, they will have an offer. If you want to accept that offer, then you could just be done with the case. If not, you're still getting released, but you'd have to show up for future court dates, okay? Huh? Well, let's see. Attorney Bake, what's the offer to resolve the matter?
Offers for court costs.
All right. So if you wanted to enter a guilty or no contest plea to the county disorderly conduct charge, then you'd have to pay $114.50 in the next 60 days or work out a payment plan with the clerk's office if you needed more time to pay. But it's not like bail that you have to post to get released. You're getting released no matter what, and then you'd have time to pay. Did you want to accept that or do you want to contest it? Okay, I'll accept that as your no contest plea to the charge. Or do you pay the court cost of $114.50? They're gonna process and release you yet today. It may take an hour or so, and they'll give you some info about making the payments. We are adjourned. Yep, oh, you're welcome. Take care.
Next is Cole Leeds.
Oh, please. We'll go on the record in the state of Wisconsin versus Cole Leeds. It's 26 CF 435 appearances.
John Bake for the state.
Mr. Leeds appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. It appears to, the address in the complaint appears to be correct. Mr. Leeds is eligible for public defender services.
Right, I'll make a finding of probable cause and state's position on bail.
State recommends a signature bond with conditions that the defendant have no contact with Mohammed D. MAHAMED, that he not possess or consume any alcohol, that he not possess or consume any controlled substances or drug paraphernalia without a valid prescription.
Right, any objections?
No.
Okay. Is there a prior history of criminal charges or failures to appear?
I see no prior record on CCAP at all.
I do see juvenile history, however, no criminal history. I don't see any warrant history either.
Okay. Well, I have a joint recommendation. I'm gonna go along with it with a little bit of reluctance. I guess the good thing in your favor is there's no adult criminal history. There's not a history of failing to appear. I realize that it's an Act 3 offense, and one of the factors is whether there's affirmative defenses. There's some suggestion of that. I don't know how that's gonna play out. But this is the type of charge where it isn't uncommon for cash bail to be ordered because of the serious nature of it. You got to make sure that you're abiding by all these particular conditions. You don't want to be picking up any new cases, and you don't want to miss court. So I'll order a signature bond. I'll order a no contact direct or indirect with Mohammed D. Order that you not use or possess alcohol, that you not use or possess controlled substances or drug paraphernalia without a valid prescription. I'm also going to order that you not use or possess any dangerous weapons as that's defined by the statute. So let me explain that. That includes firearms. It includes anything else that's designed as a weapon like brass knuckles, but it includes baseball bat can become a dangerous weapon if you're using it or you're threatening to use it in a manner that's likely to cause great bodily harm or death. If you're playing baseball, you're fine. Same thing with a knife. If you're using it to cut your food, you're fine. If you're using it to try and stab somebody or threatening to do that, then you can't be in possession of that. All right, understood?
Understood.
Okay, what about time limits?
Great question. We can waive the time limits.
Okay, we are adjourned.
Next is Willie Caldwell.
Right, both go on the record in the state of Wisconsin versus Willie Caldwell. It's 26 CF 444 appearances.
John Bake for the state.
Mr. Caldwell appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address on the complaint is correct. I don't have any information about his eligibility for public defender services.
Okay, so Mr. Caldwell, the deputy's handing you the public defender info. If you can't hire an attorney on your own after today, give them a call to see if you're eligible. If you're caught in the middle, you could apply for a county appointed attorney. I'll make findings of probable cause and are not guilty pleas to the misdemeanors. State's position on bail.
State is requesting $1,000 cash bail with conditions that the defendant have no contact with Heather B. and that he be banned from any residence occupied by Heather B. This is an Act 3 eligible case. It's a very violent case involving a strangulation, an alleged strangulation, I should say. There needs to be cash in order to protect the public. It's alleged here that the defendant was upset about the victim sending money, essentially money to other people, and that he attacked her in her sleep. The attack moves to the bathroom where he allegedly strangles her over the toilet, causing her to throw up. In light of these serious facts and the serious charge, the state would request significant cash bail.
And because it's an Act 3 eligible offense and I don't have any other information, aside from the pending battery charge, is there a prior criminal history of violent crimes?
There are, Your Honor, and there are, I believe, convictions for DC. I believe he does also have an open case for battery.
Okay, Attorney Kavanaugh.
I'm looking through this as well to find those answers too. Apologies for delay.
No problem.
Okay, well, looking through the criminal complaint, I see, and from what the state has recited, I see. I understand the concern for the alleged victim in this case. I think the no contact with that alleged victim seems reasonable and appropriate. But whether he's a danger to the public overall, this seems like a pretty specific instance of domestic of violence, specifically domestic violence against a specific person under very specific circumstances, not just in the way that every case has very specific facts, because that's always true. But I mean, the thing that seems to have spurred allegedly Mr. Caldwell to violence in this case is a combination of a specific person being in a domestic relationship, of alcohol, and of an argument over money. That's not a danger to the public generally. That is a series of things that just doesn't happen in general public. This is something that I think no contact with that particular person would be sufficient to deal with. So no objection insofar as that. I don't think cash is necessary in this case. Yeah, I'll keep it there.
All right. Well, I'm not convinced that there's a real risk that Mr. Caldwell is not going to appear in court. I don't have a lot of evidence of that. What concerns me is he's got a prior battery conviction. He's out on a battery charge, not the same victim. I think if we were talking the same victim and then these allegations, we'd be talking in numbers much greater than what the state's proposed here. I don't really see any obvious defenses. It looks like there's other witnesses to the crime here. Now, he's always got the defense that this didn't happen or the state can't meet their burden of proof. Some of the allegations here are just really beyond the pale. I mean, strangling the victim, allegedly shoving their face into the toilet, urinating on them. All of that is just extremely disturbing and concerns me, given what he's out on bail for and prior battery. I'm not gonna put any real weight on the DC. That could be words. That doesn't necessarily mean it was physical violence. I don't know the facts of that, but I think there's a need for some cash bail to protect the public. And I just am not somebody who sets less than $1,000 on an Act 3 case if I think it's necessary to protect the public. I just don't believe that anything less than that is probably going to get somebody to change their mind for things that are often impulsive. It needs to be a higher amount, so it's just really on their radar. So I'll set $1,000 cash bail, order a ban from having contact with Heather B, direct or indirect, and any residents that they are occupying temporary or otherwise. He would have the right to a preliminary hearing in the next 10 days, excuse me.
We'll keep it.
Okay, we are adjourned.
Next is Clinton Moon. Up there.
Go on the record in the state of Wisconsin versus Clinton Moon. It's 26 CF 438 appearances.
John Bake for the state.
Mr. Moon appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the complaint in this matter. We can waive its formal reading. The address on the complaint is correct. He is eligible for public defender services.
Right, we'll make a finding of probable cause, and the public safety assessment recommends a signature bond. State's position on bail.
State is requesting $1,000 cash bail with the conditions that the defendant not operate a motor vehicle. Here, the defendant's charged with a flee elude. It's alleged that he was disregarding several traffic signals. He was going at speeds of around 80 miles per hour in a 25 mile per hour zone, which was described as a highly residential area with pedestrians present. If he's not willing to stop for law enforcement, there's a serious risk of non-appearance in the future. He has 3 prior OWI convictions. He shouldn't be driving in the first place. His actions clearly show that he's unwilling to or unable to comply with the law. Therefore, state believes significant cash bail is necessary to ensure future court appearances.
Guess I'm not sure whether he's revoked right now or not. Yeah, looks like he's revoked. Attorney Kavanaugh.
I agree with the PSA. I see there are some past cases in 2017 and 2019. I guess those are the best things that I can look at. 2017 CM 197, 2019 CF 2567. He made every court date as far as I can tell in those cases. He hasn't missed court dates. I don't think cash bond is necessary in this case. I think a signature bond as requested by the PSA makes a lot of sense. There is nothing within the last 2 years of failure to appear.
Yeah, I think the PSA says there hasn't been any failures to appear in the past 2 years. There's some older than that, and perhaps Mr. Rogers has those or that failure to appear for Clinton Moon. And you're on mute, Mr. Rogers.
I'm sorry, I don't believe we have a PSA on Mr. Moon, do we? A new one?
Clinton Lee Moon Jr.
Yeah, Clinton Lee Moon Jr., 26 CF 438. I have a PSA.
Okay, 1 second then. Oh, I
Judge, I do.
1 second.
I do see a failure to appear in June of 2017 and 17 CM 197. It's a Dane County case.
Oh,
I'm looking.
what case is that? 2017.
Get it to go to the right spot.
Forever, yeah.
Oh, come on, computer. Having problems getting it to getting the machine to work for me here.
2017. Yeah, there's one. Yeah, well, it's around. I'll just point out I was mistaken on 17 CM 197, but I stand by 2019.
Sure.
I finally have it open. The 2017 case is, it just shows it as Dane 17 CM 197. There was a failure to appear at a sentencing hearing on June 26th of 17, and a bench warrant was issued.
All right, and that's the only failure to appear?
Yes, yes, sir.
Okay, thank you. Well, anything else from the state or defense?
No, Your Honor.
I'll just amend my prior statement. I apologize for the 197 issue. In 2019 CF 2567, facing, not necessarily similar charges, but still felony charges, he made every single court date on a signature bond.
I don't put a ton of weight in the 2017 failure to appear. I don't think it's like irrelevant. It's not the biggest piece of the analysis. To me, the biggest piece of the analysis is the alleged behavior when law enforcement's throwing on the lights and siren and somebody's not stopping and looting and doing allegedly dangerous driving behavior that's risking Mr. Moon's safety as well as others. To me, that's just not consistent with somebody who's going to voluntarily show up in court. I'm willing to set it at a lesser amount. Maybe not the amount Mr. Moon would hope for. I'll set it at $600. I'll order that you not operate a motor vehicle at all. You would have the right to a preliminary hearing then, at least in the next 10 days. Did he want to enforce that?
Yeah, we'll keep it.
Okay, we are adjourned.
Okay. Preliminary hearing. So today we're going to try to approach from return. Not here, guys. Or you can post it. See.
Okay, this one, sir. Next is David Sokin.
On the record in the state of Wisconsin versus David Sokin, it's 26 CF 454 and 26 CT 47 appearances.
John Bake for the state.
Mr. Sokin appears in person in custody with Attorney Clayton Kavanaugh. We've received a copy of the criminal complaint in this matter. We can waive its formal reading. The address on the complaint appears to be correct, and Mr. Sokin is eligible for public defender services.
Okay. So it looks like 26 CT 47 went out on a warrant after a failure to appear on January 22nd, 2026. Probable cause, therefore, has been found there. And I actually did not have a chance to take a look at 26 CF 454 ahead of time. And maybe while I'm doing that, I'll hear the bail arguments from everybody. There's also a PSA that recommends cash bail. State's position on bail?
First, starting with 26 CT 47, state requests $500 cash bail with conditions that the defendant not operate a motor vehicle and that he not possess any controlled substances or drug paraphernalia without a valid prescription. As for 26 CF 454, state requests $7,500 cash bail with conditions that the defendant not operate a motor vehicle and that he not possess or consume any alcohol. In the 26 CF case, the defendant's alleged to have fled from law enforcement. It's alleged that even after his car, or I suppose more specifically his tires, were hit with spikes and crashed into a concrete barrier, the defendant allegedly got out of his car and took off running. Certainly that's not behavior conducive with someone who wants to come to court and is willing to come to court. Additionally, I think the 26 CT failure to appear further reinforces that idea that the defendant will not appear to court absent some significant cash bail. However, if the court does not believe that cash bail is justified in this case, we would be asking for pretrial services monitoring for alcohol monitoring specifically.
And Attorney Kavanaugh?
Yeah, so looking at the 26 CT 47 case, I see that, I mean, I guess what I'm about to say stands for the principle that the amount of cash being asked for here is a massive escalation. He was ordered in on that case and just failed to appear for the initial appearance. In cases like that, often we can just send an email and reschedule the IA. It's a massive escalation to ask for several $1,000s of cash. I get where it's coming from. I mean, I get that the behavior is concerning. I do think that this idea that someone is more likely to not show up to court because in the moment, in a heated moment, they allege to flee. Those are different things. I get that they're somewhat analogous, but I don't think they're as direct as often the state seems to indicate. That amount of cash is just very, very high. I don't think it's necessary. There's no bail jumping in this case. It doesn't appear that the behavior was following a court order. I would ask for a signature bond in both of these cases. It's an OWI that does not require prison.
All right, and any response from the state?
No, Judge, I'd refer or defer to my prior arguments.
All right, so it looks like, so I want to make sure it's the same David. So Cohen, looks like he was convicted of flee or elude in 13 CF 537 in Dane County.
The date of birth seems slightly different, but
yeah, one's May 24th, 90, and the other's May 25 on the booking sheet. I don't know whether you're able to answer that, Attorney Bake.
I'm looking at that now.
Was able to match up that case number with Mr. Soku's jail records from 2013.
Okay. Okay.
All right, well, just to his credit in the CT file, I'm not sure whether he had notice or not. Do you have any information about that? It would generally be odd for us to order a warrant at the out of custody IA for somebody not showing up if we didn't have good information that they had bonded out of jail and were given that date or were handed a citation or a court notice. So perhaps there's some reason to believe that he was provided personal notice of that.
Commissioner, I looked back at the grid I received from the DA's office that morning on January 22nd. It says citation in hand, parentheses, also check TCJ.
I see.
So I think our belief was that it's provided the citation in hand. I'm not sure if the DA's office had any supporting information for that.
That's my understanding as well.
Okay. Well, and I've got a PSA that has him at the very top of the new criminal activity, 5 out of 6 on the failure to appear. I do have concerns about people who are fleeing, eluding, whether they're going to show up in court. And, you know, this isn't like we've got a 16-year-old who's speeding and getting pulled over by law enforcement for the first time. And I'm not excusing any of those kids who take off at 100 miles an hour and go on a chase. I've got somebody who's got a lot of experience with the criminal justice system, has been charged and convicted of this very same offense, and then allegedly did it again for nearly 6 miles at top speeds of close to 100 miles an hour. That suggests to me that he thought the danger and the consequences were worth whatever he thought he was going to get charged with. That gives me pause for concern about whether he's going to show up without cash bail on the line. I did a very short study of my own. I didn't get through very many cases. I realize it's a small sample size. I got through like 25 eluding cases one day because it did feel like I do see people on eludings, and I didn't know whether that's the underlying charge of a bail jump or whether they were missing court. And a lot of those 25 got cash bail. 8 of them didn't show up in court. Most of those were cash bail, and a lot of the others got cash bail and just didn't post. It seemed like a pretty high number. It's concerning, but I acknowledge it's not a very good scientific study for just that small a sample size. And I know the PSA suggests that that isn't a factor, but as I understand, most of the PSAs and tools, they do a much more broad category assessment, and they're looking at all traffic type related offenses, which would include OARs and other things. I don't know if that tells you much either, the fact that they haven't found that it's concerning, but I've got somebody who's eluded in the past, allegedly eluded here, and has missed court dates. I think there's a need for cash bail. I'll set $500 in the CT case. I'll order that you not operate a motor vehicle and that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I think a lesser amount of cash bail is appropriate, but given the history, it still needs to be pretty significant. I'm going to set it at $3,500 in the felony. Again, order that you just not operate a motor vehicle at all, and that you not possess or consume any alcohol at all. And I guess I wanted to clarify, I think the pretrial services was only in the alternative if cash hadn't been ordered.
Yes, Judge.
Okay. What about time limits?
We'll keep them.
Okay, we are adjourned.
Everyone.